Good day, everyone. I am Christine, the moderator for this webinar. I welcome everyone for today's webinar, that is, the Supreme Court changed the role of federal regulatory agencies. How will employers manage their compliance efforts? I would like to introduce our presenter for today, Margie Falk. Margie Falk, BHR, SHRMCB, HR Compliance Advisor, HR Compliance Solutions, LLC is a senior-level human resources professional with over 15 years of HR management and compliance experience. I would now like to hand over the floor to the speaker. Over to you, Margie.
So thank you, Kristen. Thank you for that introduction. And I want to thank everyone who's in attendance today. You could have been anywhere else, but you chose to be here with us. And for that, I am truly, truly grateful. Now, today we're going to learn about our Supreme Court decision. We're going to learn about the Chevron doctrine, how it works and how it has changed, how employers need to go forward. We're going to learn which federal regulatory agency is impacted and which regulations are impacted. We're going to learn how Texas has already challenged the Department of Labor overtime threshold. And as a result, it has been blocked before the July 2024 deadline. We're still learning about what other states have challenged the DOL overtime salary threshold and what and which audience is impacted. We're going to learn a little bit more than probably you have learned about. Okay, as in my works with compliance, it's always important on what the legislation and what Supreme Court decisions are, how they make sense, how they may not make sense, but we're going to learn things like the different details of what it is. Okay, we're going to learn how employers should mitigate how these decisions impact your deadlines, current federal regulations. We're going to learn how employers and professionals must stay on top of developing cases and know how to reconcile conflicting court decisions. In addition to using other compliance tools, we are going to give you best practices, okay, on what you should be doing while this confusion is being dealt with. So let's talk about our Supreme Court legal update. And in 2024, the Supreme Court just upended the legal world by significantly reducing the power of federal regulators and placing more authority in the hands of judges. And that's a move that's going to have a major impact on workplace regulations and compliance efforts. In that ruling, the Supreme Court overturned the decades-old Chevron doctrine. So on June 28, 2024, the Supreme Court issued its decision in Loper-Bright versus Raimundo and Relentless versus Department of Commerce. Applying Chevron, the district court in each case rejected the company's challenge to the observer rule, granted summary judgment to the government. Panels of the U.S. Court of Appeals for the D.C. Circuit and First Circuit affirmed these decisions. But what we should understand is the process. When there is legislation, when there are disputes against, these regulations, the courts have to follow a process. So the Supreme Court recently overruled the decades of the administrative law with its decision in Loper-Bright Enterprises versus Raimundo. So now that the Supreme Court threw into question the future of climate and environmental regulations in the U.S., okay, scrapping decades-old legal precedent that gave federal agencies leeway to interpret the laws according to their expertise and scientific evidence. In Chevron, the Supreme Court created a two-part test to determine when a court should defer to an agency's interpretation of the law. And so it's so important for us. Use these slides as a guide to teach you more about the Supreme Court. Why? Why should you care? Because their decisions impact our workplace, but the decision will shape how courts review legal challenges to all regulations that interpret where federal law is ambiguous or silent, including our healthcare. The court must exercise their independent judgment. Some quick facts. And so how do we kind of deal with this? Regulatory agencies that are dealing with this. What about this? It means there are different regulatory agencies that are identifying, how it impacts the court's decisions. How about real estate impact? So telecommunications, another regulatory agency that really, has the authority and has always had the authority on how to interpret things like the Communications Act, the U.S. Department of Education, the Consumer Protection, and the Fair Credit Reporting Act. All of these have an impact in our workplace as well. By overruling Chevron, the court did not overturn cases that relied on the Chevron framework. So let's look at all, as we just did, the CDC, the EPA, the FDA, and IRS, all regulatory agencies, okay, that may have an impact or not. That also crosses whether it's the workplace or our life. Not every regulation is going to be challenged. And so with today's decisions, the court has upended basic principle of our democracy, compliance issues. There are specific regulations to watch. Now, the Affordable Care Act prohibits any health program or activity that receives federal assistance from discriminating on the basis of race, color, national origin, sex, age, or disability. So here are certain other things that are impacting. Now we're getting to the workplace, Department of Labor. So there's also mitigating factors. How about the employment impact? I know we've been talking about other federal regulatory agencies, but now we're here to talk about the Equal Employment Opportunity Commission. Remember the regulations of employer group health plans. Remember, we talked a little bit about some of the impact. So let's look at some of those rules. Employers often rely on agency guidance and interpretation in their efforts to navigate complex employment regulations. I guess we have to be prepared for regulatory instability. Here's what the best practice is. Employers should consider several strategic actions. You have to make sure that you work on risk management strategy. Here's our best practices. Stay informed, review your policies, provide ongoing training for employees and managers, tailor your training programs to address specific issues, documentation and reporting key. The confusion is going to impact your compliance efforts and how employee handbook policies and how penalties may be assessed. Whether one agrees with the overruling or not, the change will bring certainly more inconsistency from case to case. Nothing changes today. The Supreme Court's decision did not address a challenge to a specific employment regulations. And there are certain implications, obviously. There may be an increase in litigation risk. Although the court has overturned Chevron, it's made it clear that prior decisions relying on Chevron have not been overturned. There's takeaways for employers. I love takeaways. And as it stands now. So what is currently at risk? Now, we're going to take a mini dive on the Administrative Procedures Act. Now, the Supreme Court issued 4 decisions narrowing agencies' power. So you're not left alone, that you are connected with the labor and employment industry. So the Administrative Procedures Act is a federal law that governs how federal agencies make rules and adjudicate administrative litigation. It establishes the default rules for how federal agencies can act and be challenged. Compliance and rulemaking changes, I'm here to tell you, from the employment perspective, these rulings mean rollback protections from discrimination and wage theft that have more leeway to do more harm to workers and their communities. Key takeaways. Supreme Court's decision To overturn Chevron deference marks a significant shift in the regulatory landscape for employers. By exercising independent judgment and not deferring to agency interpretations, courts will now play a more active role. There's challenges. Remember, we're going to end up now in, as we have for the past 30 minutes or more, in the workplace. Let's talk about Texas. The court blocks new Department of Labor rule, but only for Texas. Here's a reminder. Take a 5-minute tour of all regulatory agency websites. Okay, the EEOC, okay, remember, they provide information for not only employers, because they have to do that, their clients are employees. Well, thank you so much. Thank you for being such a good partner with me. And I want to thank everyone in attendance. Again, these trainings are here to inform you and prepare you. I hope this training has done that for you. And at this time, I really do look forward to seeing you in future trainings virtually. And please, good luck in mitigating those changes. Keep your deadlines. You're going to have to make sure that you do that. And at this particular time, I'm going to say to all of you, have a great weekend, and may all of you be safe, and so long.
Thank you, Margie. That concludes the session for today. Thank you everyone for participating. You may all disconnect now. Have a wonderful day.